A pot of boiling water wielded as a weapon, a judge pushed past her breaking point after 550 days of excuses, and a wild legal theory that blames a common prescription for a positive meth test. This is not your average day in court. We're about to witness three completely different cases, each with its own explosive moments. First, a young man in a group home whose violent rage leads to terroristic threats and a courtroom struggling to get through to him. Then a defendant who has skipped court so many times that the judge unleashes a firestorm of frustration, refusing to accept any more apologies. And finally, a woman whose freedom hinges on a controversial scientific claim about her ADHD medication, even as new evidence suggests she might be cheating the system in other ways. From raw emotion to stunning legal arguments, this session is a masterclass in courtroom drama and accountability. Buckle up, because the gavel is about to fall and the consequences are very, very real.
We need to work on your anger. You don't want to work on it? Over and over and over and over again. Don't care if you have Jesus here representing. Bad, bad, Leroy Brown. Baddest man in the whole day. What? Oh, you want this?
Brown.
Who, Stephen?
I'm about to find out. Come on.
It's okay, bring him up. It's okay. Sir.
Morning, how you doing?
Thank you for coming.
Yeah.
Is it Taquel Brown? Yes, no? Okay. Who are you to him, sir?
I'm one of the staff at the group home. He lives in the group home.
Okay. Mr. Brown, you were charged with 3 cases. You were charged with terroristic threat, actually 2 counts of terroristic threat. You're also charged with criminal mischief. On all of those cases, you're facing up to 6 months in jail and or a $2,000 fine. I'm sorry, on the mischief, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed to you if you cannot afford one. Do you understand these rights? You sure? Okay, we're gonna talk with Alex to find out what happened, and then we'll see how to go forward.
Yes, Judge. On November 13th, 2024, the officer was dispatched to a criminal mischief in progress at a group home in Harris County, Texas. Upon arrival, the officer made contact with the first complainant, a staff member at the facility, who advised that the defendant broke his bedroom TV on the previous night, and that on this day, November 13th, 2024,
Let's break down what just happened. The prosecutor laid out a terrifying sequence of events. Brown is accused of not just property damage, punching holes in walls and throwing furniture, but of making death threats and, most chillingly, attempting to grab a pot of boiling water and rice to use as a weapon. The charge of terroristic threat isn't about property. It's about instilling a genuine fear of serious injury or death in the victims, and the prosecutor makes it clear they felt that fear. The judge immediately finds probable cause, meaning there's enough evidence to move forward. But notice the dynamic here. The defendant, Mr. Brown, is almost completely silent. He's non-responsive, and the judge is having to verify his understanding through his caretaker. This creates a difficult situation for the court. How do you ensure a defendant comprehends the gravity of their actions and the conditions of their release when communication is this challenging?
the defendant tried using another resident, the second complainant's laptop, since his TV was broken. When the first complainant informed the defendant he could not use the other resident's laptop, the defendant became aggressive and angry, threw the dining room chairs in the living room and the trash cans in the backyard, then punched the living room and bedroom drywall, creating 2 holes. The first complainant stated the defendant then threatened to kill him and the second complainant multiple times. The complainant advised the defendant attempted to grab a pot of boiling hot water and rice as he threatened to kill him. Both complainants stated they felt fear of immediate serious bodily injury and or death after the defendant threatened to kill them. The first complainant advised the damages the defendant caused is in the amount of $1,500.
Mr. Brown, I'm going to find that there's probable cause to go forward on all of your cases. I assume that he's still living in the group home.
Yeah, he lives in the group home.
How can we separate? Because I don't want you to have contact with these two people. Do you understand? Are you sure? I don't want you to have contact with them, and I don't want you to lose control. If you do it again, I'm going to put you in jail. Do you understand, Mr. Brown? Yes or no? Does he understand what I'm saying? Okay.
I left the group from administration. I let him transfer to another house.
Say it again.
I moved to another house.
Okay.
Yeah, so that time they stay in contact.
How has he been with you since then?
We're gonna do that today.
Oh, you haven't done it yet.
No, not yet. We're waiting for the court order. Now that you say that transfer, we're gonna move it. But the other staff, we stopped it. Let's work there no more.
How does it take up?
Guys, please. How has he been behaving since that time?
Since the time that they brought him down here, but the other gentleman that worked with him, the staff, is not there no more. We're in contact. The only person that's in contact is one of the clients that complained about the laptop.
He's still there.
Yes, but we can move him or the other guy out of the house.
Okay.
Yes, sir.
Do you know what happens if this happens again, Mr. Brown? What's going to happen to you? If you break someone else's stuff again, what's going to happen? Do you understand?
The judge is walking a very fine line here. Instead of immediately opting for jail time, she's pushing for a rehabilitative approach centered on mandatory anger management. She recognizes that the core issue is Mr. Brown's lack of self-control. Her repeated warnings are a form of scared straight tactic, painting a grim picture of him sitting in jail for a very long time if he loses control again. This is a strategic move. By assigning him a lawyer and ordering a plan to manage his anger as part of his bond conditions, she's giving him a final opportunity to address the root cause of his behavior. However, the defendant's continued silence and passive demeanor raise a critical question: is the message getting through? The judge is betting on therapy and structure, but she's also making it crystal clear that her patience has a limit, and the next outburst will lead directly to a jail cell.
You also, I'm sorry, say it again. I didn't hear him.
He said he don't like the.
With Mr. Brown's case temporarily settled, we pivot to a completely different defendant and a radical shift in tone. The previous case was marked by the judge's patient, albeit firm, attempt to guide a troubled young man. But what you're about to see is what happens when that patience has been completely exhausted. The judge's demeanor flips instantly. Listen to the immediate, ice-cold fury in her voice as she addresses Mr. Escobar. This isn't just about one missed court date. She immediately references a long, frustrating history of him taking advantage of her. This is a judge who feels her authority has been repeatedly disrespected, and she is done with excuses. The defendant's lawyer is about to step into a judicial firestorm that has been brewing for 550 days.
We're going to go to a different house. I told him we're going to change it to a different house.
They're going to put you in a different house. But what happens if you get angry again? It can't happen again. If they put you in a different house and you get angry again and it happens again, I have no choice but to put you in.
This is a raw display of judicial authority. The judge has made her decision. Mr. Escobar is going to jail. His lawyer tries to negotiate a walkthrough which would allow him to post bond immediately and avoid being processed into jail. The judge shuts it down flat. Why? Because in her eyes, a walkthrough is the same as letting him go, and it sends the message that there are no real consequences for his actions. She explicitly states that letting him go would be enabling him. She's making an example out of him. The case is 550 days old. He's missed court 4 times, and for this judge, the time for leniency is long past. This is a textbook example of a judge enforcing the court's rules and holding a defendant accountable for repeatedly failing to comply. It's not just about this one missed date. It's about the entire pattern of behavior.
In jail. Self-control, Mr. Brown. Do you understand? Are you sure? Okay. I'm going to have you talk to a lawyer today so that we can figure out a plan how to go forward. I'll give you a lawyer. You guys need to work on a plan how to manage anger, because I don't know if he gets angry. Does he get angry a lot?
Yeah, get angry a lot, it's true.
We need to work on that. We need to work on your anger, because you don't want to work on it. You have to. What happens if you really do some damage and they put you in jail because you do something really bad? You have to understand that no one is going to bond you out. You will sit in jail for a very long time if you lose control again. That can't happen. All right, so let's do this. I'm going to have you take a seat, if you don't mind, just right back there. I need him to sign bond conditions, so he can't leave until we have him sign it, and then I'll have you speak to a lawyer here momentarily, and we'll figure out a plan. I think that as part of the bond conditions, I would like him to get a little anger management. I think it's necessary. Okay. Hey, be nice. It's not hard. Okay. Just take a seat for me a couple minutes, and then I'm going to have you talk to William, Mr. Brown. Okay.
Legislate.
Please.
Judge, is that going to be freestyle bond conditions?
Acérquese aquí, por favor.
Deputy, can you stay with
Sí,
me, please?
Solo mire.
I am extremely upset with you,
Estoy
Mr. Escobar, Tobar. You have taken off on me over.
Parecido una.
And just like that, Mr. Escobar learns a hard lesson in accountability. Despite his lawyer's best efforts, the judge's frustration over the 550-day history was insurmountable. She even dismisses his excuse about a prior attorney as utter horse, a clear sign that she believes he is the one responsible for his own situation. Now we shift gears from a case of simple non-compliance to one that is infinitely more complex, involving disputed science, alleged deception, and a defendant fighting to stay out of jail on probation. The next defendant, Brittany Defy, is accused of testing positive for methamphetamines, but her lawyer is about to present one of the most unusual defenses you'll ever hear in a courtroom, claiming it's all a misunderstanding caused by her prescribed ADHD medication. But as we'll soon see, that's only the beginning of her problems.
Over and over and over and over again,
Una vez de nuevo.
repeatedly. For you to blame it on someone else is disingenuous and not true. This case is 550 days old,
50 días de edad.
and you've taken off on me 4 different times. I think that
Creo.
have we reinstated the bond?
There's a bond set, I believe, Judge.
This is a fascinating and high-risk legal strategy. The defense attorney isn't just denying the drug use. He's challenging the science of the test itself. His argument is that his client's prescribed Vyvanse metabolizes in the body into a substance that can trigger a false positive for methamphetamine on certain drug tests. To back this up, he's not just talking theory. He mentions 2 federal lawsuits against the very same lab Harris County uses for this exact issue. This elevates his claim from a simple excuse to a plausible, evidence-based defense. He's essentially putting the prosecution's testing methods on trial. This is a bold move designed to create reasonable doubt, but it's also where the case gets even messier, as the prosecutor reveals they have more allegations waiting in the wings.
Yo creo, señoría,
$10,003. The previous bond was $1,001, which which he posted last
I
week.
absolutely appreciate your tenacity. I absolutely love you, but I have to hold him accountable. I can't let him go, and I know that you're signing on now for the first time. This is not my first rodeo with him. It's been over and over, and it would be me enabling him, telling him it's okay to do what he's doing
lo que está haciendo.
by letting him go and reinstating his bond. It's 4 different times.
Diferentes veces.
You
Usted
will now go to jail
irá a una cárcel
because of the repeated
a las repetidas.
failure to comply with bond conditions. You think this is a joke? No,
Luego una broma.
we hold people accountable. And when you repeatedly fail to show up to court
orden comparecer a tribunales.
There are consequences, and you will now see that.
Ahora,
It goes with you.
Judge,
Tell me.
o sea, señoría,
would you allow him to post the bond and do a walk?
And here's the prosecution's counterpunch. Even if the court entertains the complex argument about Vyvanse, there are other, more straightforward violations. The prosecutor brings up major issues with the defendant's car breathalyzer or interlock device. They have evidence she may be covering the camera when she's supposed to be providing a breath sample, and even more damning, that other people may be blowing into the device for her. This is a classic prosecutorial tactic. If one violation is complex and hard to prove, pivot to one that is simple and visual. Covering a camera or having someone else take your test isn't about complex toxicology, it's about clear-cut deception. This completely undermines the defense's good faith argument and gives the judge a separate, very concrete reason to believe the defendant is not taking her probation seriously.
If I get a bondsman here,
I've
they're
said-
on the way.
Okay, I'm not letting him do a walkthrough. No, because it's the same thing. It's letting him go.
I understand, Judge, but he really truly did not know about yesterday's court date. He immediately called me as soon as he found out.
Steph, I appreciate it, but you got to understand, I have to hold him accountable. I mean, if you want, I'll give you a bond reduction, but no, it's now time to pay the piper.
ahora es tiempo
Would
de-
you reduce it to what it was previously to 1,001? It was originally 100.
No, what I'll do is I'll do 5,003, okay? Because it's now 10,003. It should be 10,004 actually, but I'll do 5,004 if you want, okay? All right,
You would
goes with you.
absolutely
Se va
not.
con el oficial,
I mean,
por favor.
It's
He
4
truly
times, it's
did-
550 days.
Even
old.
if I get the bail bonds to come and
Yes.
say he truly did not get the date.
I understand. No, sorry, Steph. All
Okay. I'll go and talk to him.
right, so
I don't care if you have Jesus here representing you. This is the moment the judge lays down the law in the clearest possible terms. That line is a powerful signal that the identity or skill of the lawyer is irrelevant when the defendant's own actions demonstrate dishonesty. The judge's anger isn't about the potential false positive anymore. It's about the alleged cheating with the interlock device. She sees covering the camera or having someone else blow into it as being disingenuous, a direct attempt to deceive the court. This is the ultimate sin in a courtroom. She is putting the defendant on notice that her credibility is shot. The judge makes it clear, any more games, any more positive tests, and the consequences will be severe and swift. This warning is her final act of grace before a formal hearing that could easily result in her probation being revoked.
And I'll get a reset date on it.
So here's the thing. He's going to auto-populate tomorrow. So we're going to end up seeing him here tomorrow. So you're welcome to Zoom on tomorrow. You're probably going to end up posting bond now. So probably be out within the next, 4 or 5 hours. So, but I can't just let him go over and over and it's 500.
I understand, Judge. I don't know what happened before. He was telling me he didn't have a very good communication with the prior attorney 2 years ago or a year and a half ago. I don't know.
It's utter horse, you know what? Because we have literally reset him over and over, been working on a mitigation packet for nearly a year. So the thing is that, and I know that you're just now coming on to it, but we have quite a bit of history with him. It's over and over. We let him go over and over. And at some point I got to say what, so. All right.
Talk to him, Judge.
Thanks.
Thank you.
Hey,
How are you, sir?
sit down.
Judge, I'm here on Brittany DeFraui. She's not on docket, I don't think. When we spoke last, I had just gotten on the case. We had heard about her allegations of testing positive for methamphetamine, which was a concern to you. Since that time, and she's here, we have had an opportunity to dig into it a bit more. Ms. DeFraui apparently was taking both Adderall and Vyvanse. It appears from what we can tell from the drug lab tests that we are seeing, they may well have been testing for the Vyvanse. Vyvanse
I can't
metabolism.
imagine that Vyvanse is going to make you test positive for methamphetamine.
It can. Apparently, Vyvanse I've got the articles here. I'll be happy to share with you. But Vyvanse metabolizes down into a form called D-amphetamine, which
3 cases, 3 dramatic outcomes. Mr. Brown, the volatile young man, is given a lifeline through court-ordered anger management, but with a stark warning that jail is his next stop. Mr. Escobar, after 550 days of dodging the system, finally faced a judge whose patience had run out and was sent to jail to learn the meaning of accountability. And Brittany Defy, despite a creative scientific defense, finds herself on razor-thin ice, accused of blatant deception and now facing a high-stakes hearing that will determine her fate. From threats of violence to battles of scientific evidence, today's docket showed that in the courtroom, actions in a long history of excuses always have consequences. What did you think of the judge's Jesus comment? Let us know in the comments below and subscribe for more intense courtroom breakdowns.
It's, what is it, I'm going to mess it up, but it's deamphetamine, which will test positive for methamphetamine. In fact, the same lab testing agency that Harris County is using is now involved in two federal lawsuits for testing people positive for methamphetamine, when in fact they are not. We're trying
to see that.
Yeah, where we're trying to untangle the kind of circumstance here. We've become aware of some other allegations involving a alcohol testing device in her car. And it's my understanding there are also some email chains between my client and her old probation officer about her reporting dates and her testing. And apparently this previous probation officer had some discussions with her about knowing that the Vyvanse would test positive on the UA test. We're trying to gather all those.
But there's still other violations. And is she continuing to test and make sure that she's not using alcohol or?
The last drug test I have is from October 31st. She also is obscuring the camera in her on her device. And I didn't
Come up, Mr. Frawley.
violation. I mean, any emails between the previous officer and your client.
And I'm sorry, you don't what?
See any emails between your client
Yeah.
and the previous officer.
It's unacceptable if you're covering the device when you're supposed to be blowing into it.
She's not covering the device, Judge.
It's like obscured. It's looking at the camp, like it's looking at the sky. There's other people going into the device.
Oh, no. Oh,
If I may, Judge,
oh.
what we're seeing, there's not a routine pattern of this. What we're seeing is that there are occasions, and Mr. Frawley can speak to this, she would go back in and get everything recalibrated whenever it was brought to her attention that she was not being captured on it. To be fair, there have been occasions when other people have driven the car and they necessarily must blow in it, but it is not a pattern behavior. It is very sporadic.
Yes. And then on top of all of this, Judge, she also is on probation and felony court, and it looks like they're gonna push a motion.
If I may, I've already spoken to felony court. They're not pushing the motion. They are waiting to resolve this issue. I went up there just now, and that judge up there is staffing it and is going to try to get to the bottom of this methamphetamine problem.
I'd like to send her for a drug and alcohol test now while she's here. And then we need to have a hearing with regard to the methamphetamine and the Vyvanse issue, you know, and
I'm waiting on a letter from Jimmy Valentine, who is a nationally recognized toxicologist, about this issue. I think it's going to resolve everything, but I mean,
well, I appreciate the tenacity, but I'm going to have issues if you're trying to cover the camera. If you're trying to do things of this nature, I'm telling you now, I'm going to have a humongous problem with it. And don't care if you have Jesus here representing you, but if you are trying to be disingenuous by covering the camera, I'm telling you now, I'm going to have issues with it. Don't cover the camera. Don't have other people blow into it, because the idea is that if that car is moving and you're behind the wheel, you are supposed to be taking the breath test, not someone else, and then them allowing you to drive.
Nobody else is.
If I find that happens, I'm going to lose it. Do you understand?
Yes.
So, yeah, I'm going to send her for a test now. I want to set it for a hearing, perhaps in 2 weeks, so that I think we need to have an expert too. I mean, we need to figure out how we're going to have someone come testify on the issue as far as Vyvanse and
Subpoena someone? Or
I don't know. Let me reach out to my, my staff and figure out how we're gonna go forward. Let's do like 2 to 3 weeks. We'll set it for a hearing, a formal hearing. You know, have the probation officer ready, every allegation ready to go.
We would only ask, and we'll be happy to do that. We just asked for a list of what we're battling.
Yeah, of course. Is everything operational now as far as interlocks? Is she still reporting now?
Yes, sir. As far as I can tell, everything is still operational and she's reporting.
What is the cause number, Shatori, please?
That's here in misdemeanor. It is,
394034.
Tell me,
She was supposed to come in, to turn her stuff in and sign amended conditions to go through it. That's what she was here for.
that's right. Right.
And then,
it's not on the dock.
Why is the felony court unhappy?
because they got the same case review we did and they requested a motion from what I saw, but I guess they went upstairs. They said something else.
Who's in the 184th? Who's that?
That's Cat Thomas, Judge.
Okay. All right, so let's set the hearing for 3 weeks. Okay, and then I'm gonna get with my staff to see how we're gonna go forward as far as
Understood.
the methamphetamine issue.
Yeah, we'll be happy to share everything we find about. We're still untangling it, but you know, I've been in a lot of these problems, and this one is giving me pause. It sounds like something where we may be going down the wrong path, so I want to bring it to your attention. That's all.
Don't test positive for anything from now. And I'm telling you now, I'm going to drug test you like crazy, and I'm going to test you for alcohol like crazy. Do you understand?
Good.
Don't test positive because it's really going to go sideways real quick. Okay. All right.
Understood.
Pick a day, 3 weeks, and then we'll set it for a hearing.
Yes, sir.
Full hearing. Okay.
Do you want her to come back after the drug test?
No, if it's positive.